Morning.
Thank you
Good morning.
thank you for joining. Okay, thank you
Morning.
for joining today's session. Can I please remind all of us to keep our mics muted and only unmute it if you have a question or you want to ask something. Today we are going to talk about the dissolution of a civil marriage, specifically focusing on death. Next week we will start with annulment, and then we will discuss divorce. Termination of a civil marriage, the major party is going to be divorce and all these processes. But today we'll just talk about, we'll briefly talk about judicial separation, extrajudicial separation, and dissolution of a marriage, civil marriage through death. So my first question is, does anybody have any question with respect of judicial separation, extrajudicial separation? Do we all understand what judicial separation is and extrajudicial separation? Anyone?
Morning, ma'am. Yes, I do. I understand.
Okay, who's speaking?
My name is Jan, ma'am.
Jan. Okay,
Yes.
Jan, as you are saying you understand, just briefly tell us when we say
All right,
parties,
ma'am.
okay, just explain to us what you understand by extrajudicial separation.
Extrajudicial separation is it's an agreement between the spouses about that would stop the obligations of the marriage. But such agreement doesn't bind the third parties. It is only dependent or a link or binding them to their own agreement. And this agreement can then be further taken by one of the parties to further institute divorce proceedings.
Okay, you are correct. Thank you so much. Students, as Jan has stated, extrajudicial separation is basically when spouses decide that they are going to separate, but that separation is between the two of them. They are going to enter into an agreement where they decide the terms regarding, let's say, for example, they're married in community of property, the obligations, who's going to be responsible for child maintenance, paying any financial obligations. But that agreement is only binding on the two of them. It's not binding on third parties. And when we talk about judicial separation, firstly, it is important that I make you aware that we no longer have judicial separation. Before, apologies for that. Before Section 14 of the Divorce Act demolished or did away with judicial separation, judicial separation basically was an order by a court of law where they temporarily suspended some of the matrimonial obligations and between the spouses, but it was only temporarily. It was not a long-term separation, because if spouses needed to formally terminate their marriage, they needed to file a divorce. But Section 14 of the Divorce Act has abolished judicial separation. What we still have is extrajudicial separation, which parties are still allowed to enter into, but as long as they are aware that it is not binding on third parties. Does anybody have any question on judicial and extrajudicial separation? Can I assume that you all understand?
Yes, ma'am.
Yes,
Okay.
ma'am.
Now we're going to talk about dissolution of a marriage by death. Can anybody just explain to us, if spouses are married in community of property and death occurs, firstly, what happens? are the parties still in a joint estate even though death has occurred? What does the law say if spouses are married in community of property and one of the spouses pass away or both of the spouses passes away?
Ma'am Kathleen, both the marriage and the community of property system in terms of which the marriage operated is dissolved. But this is happening ex lege. In other words, a court does not need to be approached to condone, to approve the dissolving of the estate and of the marriage.
Okay, you are correct. Thank you so much. And can another student explain to us what is the process? Just briefly explain to us what is the process that has to be followed when death occurs. Here is a spouse, he has passed away and there was a joint estate. What is the process that must be followed once the spouse has been buried? Let's say the joint estate has death, and the surviving spouse also has a claim, or the surviving spouse has 50% share of the joint estate. So what is the process? How does the surviving spouse get their share of the 50%? What happens to the death, and who is responsible to make sure that the spouse gets what they are entitled to, and if there are children in the marriage, or if the deceased has any other children, even though they were not born in the marriage. Can anybody just explain to us what happens now in the case where spouses are married in community of property? What is the first thing that needs to happen? Maria Aris? Maria?
Yeah, ma'am. Morning.
Yes, you can talk.
I think after that, the estate has to be reported to the master of the High Court. Then the spouse will get first his 50% due to the marriage and community of property. Then the child's portion in the other 50% of the deceased spouse. Then the other heirs or the children will share.
Okay, thank you for that, Maria. The first thing that needs to happen, or the most important thing that needs to happen once the spouse has been buried, an estate file must be opened at the master of the High Court, and the executor must be appointed. Before I continue, Ethel, I saw your hand. Ethel? Ethel?
Hello,
Ethel? Yes, you can talk.
Yes, I wanted to mention what you are mentioning now, that the executor needs to be appointed to administer the estate of the deceased, or in the case where there are debts, in the case where there are creditors, so that the debts needs to be paid off, and the creditors also needs to be paid in. And again, to make sure that if there's a need for liquidation, then the executor is the responsibility of the executor to make sure that he conducts the process of liquidation until everybody gets the share of what they are supposed to get.
Okay, thank you for that. You are correct, Ethel. What is also important that you must bear in mind that if when a person dies, or when the spouse dies, it first needs to be determined: did they die with having left a will, or did they die without a will? In the case where they died without a will, which is intestate succession, an executor, as the executor must be appointed. Let's say a third party or a third organization is appointed as an executor, the surviving spouse will have limited rights to deal. The surviving spouse will have limited rights to deal with the joint estate because all the powers will lie with the executor through the process of winding up of the deceased estate. But in the event where a will has been left, the person who writes a will is called the testator or the testatress. The testator will have to state whom they want to be appointed as the executor of the estate. In the situation, the law allows that an adult individual can be appointed as an executor, meaning that the surviving spouse, can be appointed as an executor, and they have the right to appoint what is called an agent to assist them in winding up of the deceased estate. So it is important to know that in the event that a third party is appointed as an executor, the powers of the surviving spouse will be limited and they will not be able to have access, for example, to the banking account and some of the finances of the deceased up until the winding up of the estate has been processed or has been the administration of the deceased estate has been finalized. Also, what you need to bear in mind or you need to know is that when it comes to the debt, when creditors have to be paid, they will firstly look into the deceased estate. If the deceased estate does not have enough funds to cover the creditors, the surviving spouse now also needs to be liable for that. Although the surviving spouse is still alive, because the parties are married in community of property, the deceased estate will affect both the 50% of the deceased and the 50% of the surviving spouse. If there are maintenance claims, let's say the person who passed away is a husband and then the husband had children before they got married, extramarital children, those children also have a right to lodge in a claim for child maintenance, for current and future child maintenance, and the claim has to be processed first before we can move to a stage of inheritance where the surviving spouse will first need to be allocated their 50%. So it is important to be aware that before the surviving spouse can get their 50% share, all creditors' claims, all maintenance claims, and any other claims firstly need to be dealt with. Once that has been dealt with, then you will move to the stage where if the estate is has enough funds, then the surviving spouse will then be allocated their 50%. Does anybody have any question on termination of a marriage when the spouses are married in community of property? Anyone?
Ma'am Kathleen, I find this course very challenging, but be that as it may, ma'am, I read somewhere that the estate, when it has a certain value, doesn't need to be reported at the master, but I stand to be corrected. Can ma'am just help assist in that regard, please?
Okay, yes. Okay, I'm going to mute everybody because of the noise, but okay, I've muted everybody, but I've noted the hands. Once I call your name, then you can unmute yourself. You are correct. So in terms of the law, all estates that are 250,000 rands and above, those estates must be recorded, must be reported, and an executor who is a third party, or if in terms of the will is the surviving spouse or a family member, must be appointed. If, for example, the estate is less than 250,000, you can report it, but the formalities are going just to be informal. They are not going to be as strict as when the estate is 250,000 rand and above. So, for example, let's say a spouse dies and the estate only consisted, let's say they lived in an informal settlement, consists of a check which is, let's say, less than 10,000 rand, and the parties don't have anything of substantial value. Under that circumstance, they don't necessarily have to go and report it. But another example is, let's say, the estate consists of an RDP house, which is, let's say, it's 100,000 rand, and the parties also don't have anything of substantial value. They can report it because it is there is an immovable property involved. But because of the value of the house, the process that is going to be followed after followed from there on is going to be informal. As I said, versus when the estate is 250 and above. So just to answer your question, it depends on the value of the estate. The question will be, is the value of the estate worth reporting? But what you must also be aware is, if there is an immovable property, and that immovable property, even if it's 60 or 70,000, and it is registered at the deeds office, the estate must be reported, even though the administration is just going to be an informal administration. To understand before I move to the next one.
Thank you, ma'am, Kathleen. I do understand. Thank you very much.
Thank you. JC? JC? JC?
Yes, ma'am, it's me. Yes, ma'am.
It was you. Okay, please
Yeah,
move your hand. Okay. Ethel? Ethel?
Thank you, ma'am. Thank you, ma'am.
Okay.
I need a clarity. I just want to be sure that I have heard you correct. Are you saying that after the situation of debtors and creditors has been dealt with, and the remaining estate is going to be shared amongst the kids, extramarital kids, before the 50% of the spouse?
Okay, no, it's before. Let me explain what happens. Let's say the administration has been done, and now we've moved to the stage of distribution of inheritance. So the first thing that's going to happen is the surviving spouse, they're going to be allocated their 50%. Once they have received their 50%, the remaining 50% of the deceased, you're going to calculate the value. If the value is 250 or less, everything is going to go to the surviving spouse. If the value is more than 250, let's say it is 350, all the children of the deceased are only going to share, let's say, 10,000 rand. So this is how it works. The surviving spouse gets 50% by virtue of income of property, and they are supposed to get another share, which is called a child share, which is not supposed to be 250. It's not supposed to be less than 250,000. So if the estate is 500,000, everything goes to the surviving spouse. If the estate is, let's say, it's 800,000 rand, we're going to say out of 800,000 rand, 400,000 has to go to the surviving spouse by virtue of a quantity of property, and the remaining 400,000, the surviving spouse is supposed to get 250,000 rand from the 400,000 rand, and the balance that is left is going to be shared by all the children. of the deceased. So the 50% is allocated first, and afterwards the children will only get residual what is left.
Okay, I'm clear. Thank you very much.
Okay, thank you. Erisa? Erisa?
Thank you, ma'am. Yes, thank you, ma'am. I have two questions. The one is, what happens if there are no children?
Okay, if there are no
How
children,
does it get divided then? Does the surviving
the
spouse
surviving
get
spouse gets
everything?
everything. Yeah. And then if both, let's say it was a car accident and both the spouse, husband and wife, they pass away and there are no children, then the next step is who is the nearest blood relative. The nearest blood relative will be the parents. If there are no parents, it's going to be their siblings.
Okay, wonderful. Thank you.
Okay.
And then my second question, you said you pointed at an agent to help them wind up their.
Okay, can you repeat that? I didn't
Can
hear
you hear me?
Yes, I can hear you now.
Okay.
Yes, talk, Erika.
If the surviving spouse is appointed as the executor, they can have an agent to wind up the estate. Does in the will, or can the surviving spouse just choose anybody that they want to help them?
No, the surviving spouse can choose anybody that they want, as long as the agent is a professional person who knows how winding up of a deceased estate works.
Okay, wonderful. Thank you so much.
Okay, thank you. Who's next? Pilane?
Thanks, ma'am. My question was actually answered when you responded to Ethel about the child share and the 250 that the surviving spouse is supposed to get. But my other question is also on what you're actually saying, to say that the third party can actually be appointed as an executor. And I need to understand under what circumstances would a third party be appointed as an executor to the estate of the partners.
Okay, firstly, let me explain. When I say a third part, I'm talking for example, other attorneys who specialize in administration of disease estates, banks, and trust companies. Those are the other individuals or organizations that I'm talking about. The reason why they are appointed is because lay people do not understand or don't have the know-how to administer a disease estate. So if, for example, the death is intestate and the estate is more than 250,000 rands, at the master of the High Court, they are often reluctant to have the surviving spouse appointed as an executor because they don't know the know-how of doing of administering a disease estate. So that is basically the reason why you appoint somebody who is qualified and has knowledge of how to do the process.
Thank you, ma'am.
And before I take another one, can I also state that in a will, if you appoint your own executor, you can state that you don't want your executor to pay any security, because when an individual, mostly a lay person, is appointed as an executor, the master of the High Court will request that they furnish security just in case they mismanage the estate assets or the estate finances. But if in a will you have specifically stated that the appointed executor does not have to furnish security, then what you have stated is going to be adhered to. So that is something that is very, very important also in your personal capacity to know. And can I also state that it is advisable, it is advisable to have your own will and appoint your own executor, because other executors, in terms of the law, they are entitled to 3.5% gross percentage of the estate. And if let's say the estate is generating income, let's say they're into property business whereby they are leasing properties and they are receiving rent. On top of that, 3.5 percentage, there's another 6% that the executor is entitled to. And because it is gross amount, what they are entitled to, it actually tends to be an excessively high money. It tends to be a high money, large amount of money, and sometimes it happens that the executor's fees may end up being more than what, let's say, your children are going to get when it comes to the money benefit. So it is important that you appoint your own executor, and you just state in your will that your executor can appoint an agent to assist them in administering the deceased estate. Okay. Now we are moving to Pakeng. Pakeng, Pilani, please remove your hand. Pakeng? Pakeng? Okay, I'm moving. Happy Ntsingila, happy?
Thank you, ma'am. Thank you, ma'am. My question is, presumably all of this, all of the stuff that you've described assumes that the deceased spouse had no will.
Mm-hmm.
And if indeed the deceased spouse had a will, therefore it means that the surviving spouse only gets the 50% that belongs to him or her, and the rest of the people that are stated in the will, if all of the 50% has been bequeathed to them, that's basically the end of the story, right?
Okay, let me just understand first what you say. Are we talking about when there is a will or when there is no will? Because when there is a will, the surviving spouse gets their 50%, and
Yes.
the other 50% goes to the nominated beneficiaries' heirs. So the surviving spouse only get an additional amount which is not supposed to be 250,000. Basically, it can be 250,000 or more or less if the surviving spouse is the only one who's going to inherit. So only in an interstate succession does the surviving spouse get the 50% and additional money. But if there is a will and the surviving spouse has not been nominated in a will, then the surviving spouse will only get their 50%. And can I also add by saying, if you don't want your surviving spouse to get extra, in other words, if you want to make sure that all your children also get enough, the surviving spouse, you must not nominate them, because if you nominate them in a will, let's say you say my spouse will get 20%, then it means that the surviving spouse is firstly going to get 50%, and on top of that 50%, they're going to get an additional 20%. And the reason why I'm saying this thing is that practically many people, they are under the assumption that if I draft my own will and I say my wife will get 20%, my children will share the other 80%. Most of the time, they are not aware that by virtue of being married in community of property, the surviving spouse will automatically get 50%. So instead of the surviving spouse now getting 50% only, the surviving spouse will get 70%, because it's 50% by virtue of income of property, and the other 20% which has been listed in the will, and the children, instead of getting the 80%, there is only 60% left that has to go to the children. So when you advise the clients, you need to make sure that they understand that if you first need to make sure they understand that they can only give away 50% of their share in a will, even if they have a house and that house is only registered under their name. The fact that they are married in community of property, they cannot in a will just say, I leave my wife 20% of this property and 80% to my children. They must always be reminded that they can only give away 50% of their estate. The other 50%, they have no control over it.
Thank you.
Okay, thank you. Maria? Maria?
Yeah, ma'am.
Okay.
I wanted to know, I have 2 or 3 questions. The one that you just explained now, you meaning that the spouse, if there's a will, the spouse only receives the 50% if she's not or he's not nominated in a will,
Yes.
she forfeits the 250 child share.
Yes, the 250 child share only applies in interstate when there is no will. Where there is a will, it does not apply at all.
Okay. Is another question. In a marriage and community of property, is it allowed, or the other spouse is allowed to nominate somebody else other than the spouse to be the executor?
Yes. When you are married in community of property, you both have 50%. You are jointly and equally liable and share the benefits of the joint estate, but your 50%, you can decide whoever you want to be the executor, and if you want to disinherit your spouse, you are allowed to do that. Also, there is no legal obligation to also leave any inheritance for your children. As an adult, it is up to you to decide who must be in charge of your 50% of the estate.
Okay, one last thing, ma'am. The difference between the powers or the work that the agent and the executor do in the deceased estate?
Is the same. The agent is, I can say, basically is helping you as Maria. You are a surviving spouse, so you have been nominated as the executor, but you know nothing about administering a deceased estate. So they are acting on your behalf, but at the end of the day, you are the executor. They will come and give you advice that this is how it works, and the final decisions and everything they will have to communicate with you, and you are the one who must decide if yes, I'm in agreement that maybe it is in the best interest that the immovable property be sold in order to meet the creditors. And if, let's say, there's any mismanagement or there's any stealing of funds, you as the executor, you are the one who's going to be held liable. They are just the agent. They are just people who are helping you. But at the end of the day, you are the executor of the estate.
Okay, thank you, ma'am.
Okay. Joretta Parsons? Joretta Parsons? Okay, let's move. Nonhlanhla?
With regard, it's Nonhlanhla here.
Okay.
With regard to the agent, can I pay them any amount, or is it stipulated in law?
With the agent, it is not stipulated. So you can enter into an agreement with them, because I know that there are some law firms which specializes in administration of deceased estate, and instead of charging the 3.5 percentage, they will actually charge 3%, or they will charge 2%, but also that depends on the value of the estate. So if the value of the estate, let's say, is quite excessive, so they will say, okay, we'll just charge you 2% or so, but you can negotiate with them. Versus when it is the master of the High Court who instructed that as the family or you, the surviving spouse, you must go and get somebody or a company or a bank who are qualified and have the know-how, and that person must be appointed as the executor. Then under those circumstances, you will have no choice but to stick to the fees as regulated by the law.
Okay, I also have another one. Earlier on, you said the claim for maintenance needs to be settled first before the surviving spouse can access the 50% share and inheritance. But I also heard you saying that the surviving spouse needs to get their 50% share first.
Okay.
Yeah.
Administration of a disease estate, let me say, look at it in two ways. There is the process of administering the disease estate. That is, creditors lodge their claim. The surviving spouse can also lodge a claim for spousal maintenance in terms of the maintenance of surviving act if the surviving spouse is in need of maintenance, and any children who any dependent children who are in need of child maintenance and can prove their claim must lodge their claim. Then this is the first process that is going to be dealt with. So once the administration of a disease estate has been finalized, the second process is distribution of inheritance. And distribution of inheritance, the first thing that needs to be determined is what the spouse married income of property. If the spouse was married income of property, 50% share is going to be allocated to the surviving spouse. Once that has been allocated to the surviving spouse, then whatever is remaining, the first question is going to be, if it's interstate, the first question is going to be, okay, does the estate have enough to pay 250? So it's going to depend on the value of the estate. If, let's say, after the 50% has been allocated, what is remaining is, let's say, 2 million rand, then the surviving spouse and the children are going to get an equal share. If after distribution of the 50%, what is left is 250 or 270, then the whole amount is going to go, not the whole amount, 250,000 is going to be allocated to the surviving spouse, and the children will just share that 200,000 rand. But what you must know is nobody has a right to inherit before the valid claims by creditors, maintenance, both spousal and child maintenance, have been met. Once this is done, then you move to the second process. And this also applies when spouses are married out of commit of property with the accrual. Once administration of a disease estate of the disease has been done, the next step is, okay, calculation of the accrual. But the calculation of the accrual, it is done through the process of administration of a disease estate, because it needs to be determined that whose estate is larger. Is it the surviving spouse or is it the deceased? If the surviving spouse estate is larger, then the surviving spouse has to pay an accrual share to the deceased estate. And if it is a deceased estate, then the deceased estate has to pay the surviving spouse, and the surviving spouse is going to be paid through the process of inheritance. So do you understand now that just know that the creditors, maintenance, and everything, that is a part of administration of the disease estate, and the second party is the process of distribution of inheritance. But that is done once the surviving has been given their share of 50% or accrual if their estate was lesser than the deceased estate.
Thank you, I understand.
Okay, thank you. Sinenhlanhla?
Ma'am, I have a question. My question is, what happens if I have a client, maybe it's a child diseased, and then he come to my office and say, my father has businesses, and then but then I was not included in their marriage. I was outside side chick baby. What must I do to claim? Because my father was paying school fees for me. My father was doing this for me. My father was fully supporting me, but now my father is dead. So where should I go?
you report at the Master of the High Court. Once an estate file has been opened, or if an estate file has not been opened, but whether you are a child or a creditor, you have the right to go and report to the Master of the High Court. There is usually a form that they complete, and the Master of the High Court, they will write a letter calling upon someone seeing the family member. Let's say in this case, someone seeing the spouse, the surviving spouse, calling her to come to a meeting with the Master in order to deal with this. But you report at the Master of the High Court. Do you have any other question?
No,
Okay.
I'm fine.
Thank you. Cynthia? Cynthia?
Sorry, ma'am. Can you hear me?
Yes, we can hear you. Is it Cynthia speaking?
Yes, this is her.
Mm-hmm.
Ma'am, I just wanted for you to clarify. So you said the maintenance will be paid first before the spouse gets 50%, or the spouse gets their 50% first before the maintenance claims can be done.
Okay. What I'm saying is all valid claims against the deceased estate are going to be met first, are going to be, money is going to be allocated first before the surviving spouse can be given their 50% share. So remember I said, although the surviving spouse is still alive, because the parties were married in community of property, they have one joint estate. So all obligations of the deceased, they form part of this joint estate. So that is why all claims, valid maintenance claims, both spousal, meaning that the surviving spouse can also lodge in a spousal maintenance claim, and any dependent child, they're going to, they can lodge in, and if they have valid claims and creditors, funds are going to be set aside so that all valid claims are going to be paid. Once that has been done, let's say out of an estate which was worth 4 million rands and 2 million is set aside to cover all valid claims brought against the estate. The remaining 2 million, the surviving spouse is going to get 1 million rent, which is 50% by virtue of community of property. And the remaining 1 million, if let's say there was only one child in the marriage, then the surviving spouse is going to get 500,000 from this, and that one child is going to get 500,000 from this. So what you must know is all valid claims have to be met first. So in other another example, what I can say, if the estate, let's say the estate has valid claims which are worth about 1.8 million, and there is nothing afterwards. There is nothing. This was all the debts that has to be paid, all the valid claims, and other than this, the estate has nothing. This means that the surviving spouse is not going to get anything, because this is what needs to be covered first before we can say the surviving spouse, here's your 50%. Do you understand?
Yes, I do. Thank you very much.
Okay, thank you. Paul Elsie?
Okay, let's say they have no children, and then the mother is already pregnant and already left with 2 weeks to give birth, but the father dies within that 2 weeks and without updating their will. So will the fetus also inherit from the will, or will the mother only inherit from the will?
No, the mother can bring in a claim on behalf of the fetus, and let's say there are no issues and they approve it, but on the condition that we'll set aside money and wait for the child to be born. So in other words, money can be set aside, but it can be put in a trust. So awaiting the birth of the child. So let's say it's a stillborn, then it means that claim will no longer be valid. But if the child is born alive and some executors will demand a DNA test. So let's say DNA tests are done and it is proven that indeed the deceased is the father. Then money for current and future maintenance then is going to be set aside for that child. But that claim must be lodged. So it is also important to note that you have to lodge a claim. The executor will not just automatically include the child without the mother lodging a claim on behalf of the forthcoming child.
Okay, thank you.
Thank you. Nomvula? Nomvula? Okay.
How are you?
I'm okay, Nomvula.
I'm good, and you? I have a question here. And let's say there is a man, and then maybe that a spouse, a man, and maybe he marries two wives, ne? And then in these two wives, he has children in both sides. Maybe the first wife, he married him, and then he married the wife, and then they signed. They got married in a community of property, and then the second wife, they just did a customary marriage, traditional marriage. They didn't sign, and then the man had maybe extramarital kids outside of the marriage before. Maybe he married the first wife, and then he makes a will, and then in the will, the first wife and the second wife and the extramarital kids are there. So how is the estate going to be distributed?
Okay, let me just confirm. Did you say the first wife was married civilly and the other one was married customary?
Yes.
Okay, firstly, the second marriage is going to be null and void. Remember, a civil marriage is monogamous and it's between a man and a woman. So the other woman will be what I will call a celebrated girlfriend. A celebrated girlfriend in the sense that they had all this function, lobola was paid, maybe they had in inverted commas, a customary celebration, but in terms of the law, everything that was done is null and void. So if they are married in community of property, the first wife is going to get 50% by virtue of being married in community of property, and then the second step is looking at what they will say. So if the civil wife is nominated, let's say the deceased husband is giving them 20%. Then everybody is going to get 20%, meaning that the civil law spouse will get 50% and a further 20%, and that other woman is going to get 20%. The fact that their marriage is null and void does not disinherit her if she has been nominated in a valid will. But in the case of interstate succession, where there is no will, then because the marriage is null and void, she is not going to get anything. But the children are going to get because they are the blood or adopted children of the deceased.
Oh, okay. So basically, we are saying that the first wife will get 50%, and then if maybe in the will we are also nominated that she must get maybe a 10%, so it's gonna be extra. So it's gonna be 60% for her now.
Yes.
Oh, okay.
Okay.
Okay. Thank you.
Sipiwo.
Good morning, ma'am.
Morning.
My question is with regard to the spousal maintenance claim.
Mm-hmm.
If the spouse is the nominated executor,
Mm-hmm.
Where does she lodge the claim then? Because she's the one who's claiming the maintenance, and then she's the executor. How will that work?
Okay, she lodges a claim in the estate. Remember, the executor, I will say, they play an administrative role. And as a wife, she must lodge a claim, and then everything that is done in the estate file, the master has to approve it. So she nominates it, and she must prove that she is in need of maintenance. She is in need on maintenance, and that the estate must the estate has enough funds to maintain, or has enough funds to be able to pay for disposal maintenance. So as long as she lodges it and she follows the proper process, and the master okays it. In other words, she approves it, but the master at the end of the day has to sign off, has to make sure that there has not been any illegality, there has not been any fraud that has been done on the estate. So you lodge it on the estate file even if you are the executor. So what you must know, that is important, is that the executor plays an administrative role. Understand? So the executor, again, either in a will or through interstate succession, also has a right to inherit from the deceased estate, and they can only inherit the appropriate share. In other words, if the estate is interstate, get whatever they're entitled to, even if the executor was another person. Even in a testate succession, it has to be that way. So you play your administrative roles, but also, again, you have your head as an executor, but also you have your head as the surviving spouse. You also have this other head as the mother or as the father of the dependent children, who you also must make sure that their valid claim will also be paid if the estate has enough funds.
Thank you,
Okay,
ma'am.
do you understand?
Thank you.
Okay. Nonhlanhla, is your hand up? Nonhlanhla?
No, it's not.
Okay, thank you. Bilani, is your hand up?
Yes,
Bilani?
it's
Okay.
up, ma'am. I wanted to just understand as to what happens in the event people are married in community of property, and then the one partner opens up a trust. Would the surviving spouse manage to have access to whatever has been put into that trust? And also depending on who the other trustees are, because if the husband dies and the husband has got a trust, that's all that I need to understand, as to then how does the surviving spouse manages to actually have access to what is in the trust. Or it's like if the will itself might actually say, put all my assets into the trust. Well, maybe in that case, maybe you might find that it will mean the 50%. But what is different with the trust is that money will have been put into the trust. That needs to be taken into consideration when the division of assets has got to be made. Thanks.
Okay. Firstly, you must note that a trust is a separate and an independent legal entity. So everything that is in the trust does not form part of the joint estate. Secondly, when you are married in community of property, you cannot just open a trust without the consent of your spouse. But there is okay, let me put it that way. In your capacity as a spouse married in community of property, you cannot open a trust without the consent of your spouse. But let's say you have a PTY business. A PTY business does not form part of a joint estate. So you, as a spouse, you can open a trust in your capacity as a director of your company, which does not form part of a deceased estate. And then let's say you leave a will, and then you say in your will, I want the trust maybe of the business. You'll say, I want everything that is mine, which is under a trust party, which is under my business. You can do or you can give it away to whoever you want, because it will not form part of the joint estate. So as a surviving spouse, you do not have any say or any powers over that trust. So what the first thing that needs to be determined is if there is a trust, was it validly created? Was it created by my spouse in his capacity as a director and owner of a PTY company, and he followed the correct processes? If he did that as a spouse, so you don't have any say. But if he created a trust in his individual capacity and he somehow managed to create it without your consent, and then there are assets there, as a surviving spouse, you can bring in a high court application to challenge the existence of that trust on the basis that some of the assets that are in that trust form part of the deceased estate, of the joint estate. And as a surviving spouse, you have 50% claim over that. So do you understand how?
Thank you, ma'am.
Okay.
Yes, I understand now. Thanks.
Thank you. Who was speaking? Pilan. Who was speaking?
Yes, it was Pilan.
Pilan. Okay, please remove your hand. Maria, is your hand up?
Yes, ma'am.
Okay.
I wanted clarity on the 3.5. I heard you mentioned executor's remuneration, I think.
Yes.
Does it go to the person administering or winding up the estate, the executor or the agent?
No, the executor.
Who does it go to?
Okay. Remember the agent. Let me just give an example. Let's say there is a family law disease estate attorneys, and family law disease estate attorneys, they can be appointed as executors or they can be appointed as agents. But as executors, let's say in an interstate succession, and they're entitled to 3.5%, that money is their fees, it's gonna go to them. As agent, whatever fee has been agreed upon, even if it's a 2% from the gross value of the disease estate, it is going to go to them, because the 3.5% is the service fee of the administrators. The only difference is if you appoint a surviving spouse as an executor, they are not entitled to this 3.5%. Or if you appoint a family member in the will, they are not entitled.
Okay, so I'm the spouse and I'm the executor. I don't get the 3.5.
No, you don't get it.
I have appointed agents. Do they get the 3.5 or the agreed amount?
Yes, they either get the 3.5 if that was the agreed amount or whatever agreed amount. Because remember, they are rendering a service.
Okay.
Yeah.
All right.
Okay, thank you. Busisiwe? Busisiwe?
Yes, ma'am. Hi,
Okay.
sorry. Ma'am, I have just one question, I think. How many times can either of the spouses change the will? Let's say before either one die.
There is no limit. You can change it as much as you want. The rule is the last dated valid will, that is the will that is going to be valid. So if, let's say, you have passed away, we go to your wardrobe and we find 5 wills, the others we have scratched. What we are going to look for is the last dated valid will that is going to be the applicable will.
Okay, ma'am, thank you. And then the other question, can you appoint your child to be an executor?
Yes, you can appoint your child. You can appoint anybody, but the most important aspect, or the most important thing that you must know is just make sure that in a will you also state that an agent must be appointed, because Not many people know the process of administering of a deceased estate, and you don't want any mistakes to be done. So you are free to appoint whoever you want to appoint, as long as you also put in a provision for an agent, because that is very, very important. You don't want your spouse, you don't want the surviving spouse or the child to have challenges and to end up maybe having being sued by the creditors because they did not follow the proper process.
Okay, ma'am. Okay, thank you.
Okay, Malichaba.
Yes, thank you, ma'am. I wanted to know what happens if the children are over 18 years and the deceased didn't have like a will. If they are 30 and above, do they still have a claim?
Yes, they still have a claim. You inherit not because of the age you are, but because you are the biological child of the deceased, or you have been validly adopted, either through a valid customary law adoption or adoption, the other adoption that is being done through the social workers and all of that. So also again, what you need to understand, or what you must know, and you must make sure that clients understand easy. Even if, let's say, in an interstate succession, the estate, let's say the parents both die and the husband and wife both die, and they leave an estate worth, let's say, 800,000, and out of that 800,000, there's 6 children, and out of the 6 children, 2 of the children are multimillionaires. Those children who are multimillionaires, they still have a right to inherit, even if, let's say, out of the 6 children, 3 are unemployed, 2 are multimillionaires, and 1 is just doing okay. So it does not matter your age, it does not matter your financial status. So if a multimillionaire says, I want my share, even though I know that at the end of the day, we are each going to get, let's say, 90,000 or 80,000, there is nothing you can do about it. And but in law, any beneficiary has the right to say, okay, I don't want to inherit. We can enter into what we call a distribution agreement, whereby their inheritance is going to be given to somebody else. But they must voluntarily state that they don't want to inherit. Even the surviving spouse, if the surviving spouse doesn't want to inherit any inheritance, then their inheritance can be distributed to the children, and a distribution agreement will have to be entered into. Okay, Tsakani, who was speaking now? Was it Tsakani?
Malichab.
Oh, Malichab. Okay, sorry about that. Tsakani?
Ma'am, I want to understand where there is a situation whereby a man has a child with a lady outside, and now the child is above 18, but the man has been avoiding to pay maintenance. Should that man pass away, and his wife is also aware of the child, should that man pass away and he's been avoiding to pay maintenance, will the outside child still be able to get something from the father?
Okay. Anybody who has a valid claim can lodge a claim. So let's say the child is 18 but attending tertiary education, meaning that the child is still dependent. The mother will, not the mother, the child, when you are 18 years and above, you have to bring a maintenance claim on your behalf. Not your parents cannot bring it on your behalf. You must do it yourself. So the child, maybe with the assistance of their parent or their mother, they can lodge a maintenance claim. And what happens is the executor has the right to say, okay, before we can approve this claim, DNA testing needs to be taken to ensure that this 18-year-old girl or boy is the biological child of the deceased. If the DNA tests are positive, then their claim will have to be declared valid because they are dependent. It does not matter that there was no relationship between the deceased and the child, and that the deceased did not pay, let's say the deceased was not paying maintenance, that the deceased did not pay maintenance. It really does not matter at all. What matters is, can it be proved that a valid claim, do they have a valid claim at the time? And basically is the child the biological child of the deceased, and secondly, is the child still dependent? If they can prove this, then their claim is valid. Okay, do you
Okay,
understand?
thank you, ma'am.
Okay,
Yes,
last
ma'am.
one we're going to take again. Last one again. 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 Okay, last one will take Bongani. Bongani.
Good morning, how are you?
Morning, Bongani.
Hi, I do not have a question, but I just wanted to say you are doing an absolutely amazing job. The way you break down everything, you're amazing. Everything is clear. Thank you very much.
Okay, thank you. Students, thank you, Bongani. Students, thank you for joining today's session. Thank you for joining today's session. I have, as usual, I have drafted notes which I'm going to upload later today. But feel free to send me an email if you want to talk to me about any aspect of the other sessions or today's sessions. And please, for next week, please study for next week, because the next week is an important one. We are going to talk about termination of a dissolution of a civil marriage through a divorce. So please make sure that you prepare for next week's session. Have a lovely day ahead. Goodbye. Bye, students.
Bye.
Bye.
Thank you.
Bye, ma'am. Bye.
Bye-bye.
One last
Love
question.
you.
Bye.
Bye, thank you.